Hey YouTube, it's your girl Duchess here live with breaking news in the YSL trial. We have been waiting for a couple of weeks. The trial has been halted um, with the recusal motions of Judge Glanville, the judge that has that has presided over this case, and who held the ex parte meeting. And there was some concern that Judge Rachel Krause would not handle business and do her job. And she has. So he has been recused. And we're going to get into this article. So, breaking news: Judge presiding over YSL trial recused from case. Fulton County Chief Judge Ural Glanville will no longer be in charge of the ongoing gang and racketeering trial against Young Thug and his alleged associates. Superior Court Judge Rachel Krause on Monday granted the motions filed, Monday is today, on behalf of the Atlanta rapper and his co-defendant, Deamonte Kendrick, to recuse Glanville from the longest trial in Georgia's history. The motions were filed after Glanville held a secret meeting last month with prosecutors and a key state witness, Kenneth Copeland, in chambers. In the order granting recusal, Krause said that the Fulton clerk should reassign the trial to another judge using the court's case procedures. Kendrick's attorney, Doug Winsting, said in a statement that his client should be granted bond now that Glanville has been removed from the case. While we continue to respect Chief Judge Glanville, we agree with Judge Krause that Judge Glanville's actions at least give the appearance of impropriety. We also maintain that Chief Judge Glanville was biased against Mr. Kendrick and the other defendants in this case. Winston said, "We look forward to trying this case before an unbiased judge to a just conclusion that will free Mr. Kendrick." Brian Steele, the attorney for Young Thug, whose real name is Jeffrey Williams, could not be reached for immediate comment. District Attorney Fannie Willis declined to comment on Krause ruling through a spokeswoman. Glanville has been presiding over the case since it was indicated in May 2022. Indicted. I can read y'all for real. The case was reindicted in August of 22, but jury selection didn't begin until January 2023. After a 10-month jury selection process, opening statements took place in November. In her order, Krause says she generally agreed with Glanville's assessment regarding the propriety of the June 10th meeting, adding that nothing discussed in the meeting was inherently improper. That's interesting. However, she did note that the meeting could have or perhaps should have been held in open court. So it's interesting that this judge says that them, pressuring this witness and all of the jail, threatening him with jail fine was not improper. That's very interesting. Citing case law, Krause took issue with Glanville's July 1st comments about the recusal request. She said he added facts, provided context, questioned the veracity of the allegations, and otherwise explained his decisions and actions, and argued why those actions were proper. Krause said a judge can disclose information about their potential recusal, but that must be done objectively and without argument. This court has no doubt that Judge Glanville can and would continue presiding fairly over this matter if the recusal motions were denied. But the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from further handling of this case, Krause wrote. The trial reached its 100th day of actual proceedings, July 1st, the day Glanville announced he would pause it to allow a different judge to determine whether he would remain on the case after multiple motions to recuse were filed. I mean, this is a win. It's definitely a win that they have recused him. But I find it interesting that she's also excusing or making, I don't even know, making allowances for his behavior on this case. So let's get into her motion and how this came about. So We are going to look at this document here from the state of Georgia, order on motions to recuse Judge Glanville in the Superior Court of Fulton County, state of Georgia. The case before the court to consider is various motions to recuse, including defendant Deamonte Kendrick's motion to recuse Chief Judge Ural Glanville, filed on June 12, 2024. Caleb Bumpus' motion to quash on the show cause order and to recuse Judge Glanville. Caleb Bumpus is the attorney that was standing in with Kenneth Copeland in that in parte meeting. Defendant Jeffrey Williams, I believe that is Young Thug, motion to disqualify recuse Judge Glanville from all further dealings in the above referenced case and amended supplement. The specific facts necessary to determine these recusal motions are well documented in affidavits, court filings, certified transcripts, and video recordings available on YouTube. Having considered the record evidence and applicable case law, the court finds as follows. This court previously considered and denied defendant Kendrick's motion to disqualify Fulton County Superior Court judges from ruling on recusal motion and the portion of defendant Williams' amendment supplement that sought this court's recusal. These recusal motions arise out of a multi-defendant prosecution brought by the Fulton County District Attorney's Office alleging gang activity and associated crimes. Although there were 28 defendants named in the indictment, only 6 were being tried as of June 7, 2024. The motions to recuse all arise from the same circumstances related to state's witness Kenneth Copeland. On June 7, 2024, the state intended to call Kenneth Copeland to testify. Prior to his testimony, counsel for Mr. Copeland, Jonathan Melnick, appeared and indicted in open court that Mr. Copeland did not wish to testify and intended to invoke his Fifth Amendment privilege against self-incrimination. Judge Glanville brought Mr. Copeland into court and discussed with him the effect of an immunity order Judge Glanville had entered the grant immunity to Mr. Copeland. Y'all, I'm going to pause for just a moment. Okay, I just wanted to make sure that I was on the stage. Get back to this thing. Okay. Judge Glanville had entered the grant immunity to Mr. Copeland. Judge Glanville specifically advised Mr. Copeland that if he invoked the Fifth Amendment and refused to testify, the state would ask for Copeland to be held in contempt and jailed. Judge Glanville also advised that if asked, Judge Glanville would jail Mr. Copeland for refusing to testify. After that discussion, Mr. Copeland spoke to his attorney and then indicated he would testify. Once called, Mr. Copeland was asked to specify his age, and instead of answering, he stated, "I plead the Fifth." Judge Glanville excused the jury. Caleb Adams' case was severed, and though he is not currently on trial, his case was transferred to his court because Caleb Bumpus' motion to recuse Judge Glanville in association with the show cause and contempt issue was filed in Mr. Adams' portion of the document. See certified transcript. Okay, that was a break I didn't need to do. Let me go back to the previous sentence. I plead the Fifth. Judge Glanville excused the jury and then advised Mr. Copeland in open court that he was in contempt and ordered him jailed until Monday, June 10, 2024. At which time, Glanville told Mr. Copeland they would revisit Mr. Copeland's willingness to testify. Mr. Melnick spoke to Mr. Copeland and then reiterated to the court that Mr. Copeland still intended to invoke his Fifth Amendment right if called as a witness. Judge Glanville indicated he would revisit the issue with Mr. Copeland on Monday, June 10, 2024 at 8:30 a.m. and court was adjourned for the day. And so this is the weekend that they held him in jail. Mr. Kenneth Copeland did not allow him to speak to his attorney during the time. And they moved him over to another jail, DeKalb County, a different county, so that no one could locate him. And, according to Kenneth Copeland, stripped him of his clothing, said that he was at risk of taking his life, and stripped him of his clothing, basically made it almost impossible to endure that weekend stay, and then brought him in on Monday and had that ex parte meeting. So on June 10th, 2024 at approximately 9:10 a.m., Judge Glanville met with counsel on the state Adrian Love, and stand-in counsel for Mr. Copeland, Caleb Bumpus. The meeting took place in Judge Glanville's chambers, and counsel for the trial defendants did not participate in the meeting and were not aware that the meeting was taking place. The transcript reflects that Ms. Love told Glanville that she wanted the meeting to both impress upon Mr. Copeland the risk of refusing to testify and allow Mr. Copeland to ask questions before he testified. Ms. Love also expressed concerns to Judge Glanville about Mr. Copeland's representation. Ms. Bumpus, Ms. Love, and Judge Glanville also discussed the scope and effect of the state's grant of immunity to Mr. Copeland. Mr. Copeland was then brought to Judge Glanville's chambers, where he spoke with and asked questions of Ms. Bumpus, Judge Glanville, and Simone Hilton, counsel for the state, who had joined the meeting. During that time, the state advised Mr. Copeland that he could remain in custody until the conclusion of the trials of all defendants in the case, not just the 6 currently on trial. Judge Glanville discussed OCGA 24-5-507 with Mr. Copeland and his rights and responsibilities as a grant of immunity. Mr. Copeland spoke privately with his standing counsel, Ms. Bumpus, and then advised the court that he would testify after the meeting and immediately before Mr. Copeland was brought out to testify. Defendant Williams' lawyer, Brian Steele, advised the court that he was aware of the in-chambers meeting that morning. Mr. Steele objected to the ex parte meeting, and a lengthy colloquy occurred between Mr. Steele and Judge Glanville, in which Judge Glanville inquired how Mr. Steele became aware of the chambers meeting. Mr. Steele declined to reveal the source of his information, and Judge Glanville held him in contempt. Though Mr. Steele was allowed to remain in the courtroom on behalf of his client, Defendant Williams, ultimately Kenneth Copeland did testify on June 10, 2024, and was later released from custody. The next day, Judge Glanville issued a show cause order requiring everyone present at the ex parte meeting to appear and show cause as to why they should not be held in contempt for disclosing information about the ex parte meeting to defense counsel. An amended show cause order was later entered, setting July 1st, 2024, for an in-camera review of the transcript of the ex parte meeting. The first motion to recuse filed by Deamonte Kendrick on June 12, 2024. Mr. Kendrick's motion seeks to recuse Judge Glanville for his involvement in the allegedly improper and coercive ex parte meeting with the state. On June 14, 2024, Judge Glanville denied the motion. Judge Glanville determined the recusal motion was timely, supported by an affidavit, and on a cursory review, contains assertions of fact to support the allegations of bias and partiality. However, Judge Glanville ultimately determined that because there was no way to verify the veracity of the information contained in the affidavit, and there was no actual evidence of the extent of the discussion during the in-chambers meeting, the affidavit was legally insufficient, and the motion to recuse did not require referral to another judge for consideration. On June 14, 2024, Caleb Bumpus then filed a motion to quash the show cause order and to recuse Judge Glanville from presiding over any contempt action against Ms. Bumpus, resulting from alleged disclosure of this ex parte meeting on June 17, 2024. Jeffrey Williams filed his motion to recuse Judge Glanville. Divorced from its hyperbole, Mr. Williams' motion and supplement also seek to recuse Judge Glanville because of his involvement in the ex parte meeting, which Mr. Williams also alleges was improper and coercive. Mr. Williams' motion alleged both actual basis and appearance of bias because Judge Glanville allegedly participated in the accusatory process when he met with Mr. Copeland, and Judge Glanville became embroiled in a controversy when he held Mr. Williams' lawyer, Brian Steele, in contempt. There is an insert that says technically Mr. Steele's counsel moved to recuse Judge Glanville from further handling of the contempt action during the June 10th proceedings. However, that motion was made orally and it is not before this court because Mr. Steele's contempt matter is currently pending before the Supreme Court. Although referred to this court for consideration, Bumpus' motion to recuse is both premature and mute because Ms. Bumpus has not yet been held in contempt and because of July 1st, Judge Glanville canceled the show cause hearing. So that is addressing where Kayla Bumpus filed that motion because she was certainly certain that he was going to file her in contempt as well. If you go back and kind of see some of the footage, he forced her to remain on site, although she was technically fired and dismissed and all of that. He was trying to get to who leaked this information. Back to the reading. On July 1st, the day appointed for the parties to review a redacted transcript of the ex parte meeting, Judge Glanville announced that he was releasing the entirety of the transcript of the ex parte meeting and was taking judicial notice of and making a record regarding certain matters associated with the ex parte meeting. Most of what Judge Glanville relayed was a collation of record evidence about the recent circumstances in the case. Judge Glanville also explained how he became aware of the state's request for an ex parte meeting. In addressing the circumstances of the contempt against Mr. Steele, Judge Glanville explained the court's purpose and concern in pursuing information about the security and confidentiality of his chambers. Judge Glanville advised that he had not instigated an investigation into surveillance footage, but he had reviewed such footage for timeline and security. Judge Glanville then explained his view that the ex parte meeting was proper under Georgia law and outlined relevant law that supported his inherent authority to hold such a meeting. Judge Glanville maintained that no one gained a tactical advantage as a result of the ex parte nature of the meeting. Judge Glanville also questioned defendants' rights to be present at the ex parte meeting because the issue under discussion was between the state and a witness who was represented by counsel. After making this record, Judge Glanville announced that the show cause hearing was canceled and that the recusal motions filed by Mr. Kendrick, Mr. Williams, and Ms. Bumpus were being referred for consideration by another judge in accordance with Uniform Superior Court Rule 25.21 through 25.7. The motions to recuse were then assigned to this court for consideration. I find it interesting that he initially ruled that he would stay on the case, and after a weekend, I'm sure of some counseling and some, additional concerns, he was made to follow this law. I still say he didn't do that on his own accord. But back to this reading. Legal framework, excuse me. Motions to recuse are governed by a specific legal framework outlined in Rule 25 of the Uniform Rules of Superior Court. A party seeking recusal must file a timely motion supported by an affidavit, clearly stating the facts and reasons for the belief that bias or prejudice exists. The affidavit must be definite and specific and describe circumstances of extrajudicial conduct of statements which demonstrate either bias in favor or any adverse party or prejudice toward the moving party in particular, or a systematic pattern of prejudicial conduct toward persons similarly situated to the moving party, which would influence the judge and impede or prevent impartiality in the action. Bare conclusion and opinions are not legally sufficient to support the motion or warrant further proceedings. Once such a motion is filed, it is the duty of the assigned judge to temporarily cease to act upon the merits of the matter and assess the timeliness and legal sufficiency of the affidavit and alleged facts. If all three criteria are met, i.e., the motion is timely, supported by an affidavit, and the facts alleged might warrant recusal, another judge shall be assigned to hear the motion to recuse. When considering a motion to recuse, the assigned judge should be guided by Rule 2.11 of the Revised Code of Judicial Conduct, which provides that judges shall disqualify themselves in any proceedings in which their impartiality might reasonably be questioned. The standard is objective from the perspective of a reasonable, fair minded, and impartial person rather than the affected judge or other interested parties. If a motion to recuse satisfies the three threshold criteria, the assigned judge must refer the motion for reassignment and may not oppose the motion. The judge whose recusal is sought may not respond to the motion or attempt to refuse the allegations, which stand denied automatically, no matter how false or even defamatory the judge might know or perceive the allegations to be. A judge cannot become actively involved in presenting evidence or argument against a motion seeking his recusal without the defense itself becoming a bias for recusal. A judge has no interest in sitting on a particular case. At most, his interest lies in protecting his own reputation. His efforts at defending himself against a motion to recuse will inevitably create an appearance of partiality. One reason is that he defends himself, he becomes an adversary of the movement for recusal. This adversarial posture may create an antipathy which persists after the motion to recuse is denied. Analysis and discussion. Here, Judge Glanville had previously announced on the record that the motions were timely and supported by an affidavit. In transferring the cases to another judge for consideration, Judge Glanville necessarily determined that the third criteria was satisfied, i.e., that recusal might be authorized if the facts alleged in the motion were assumed true. Therefore, Judge Glanville was required to refer the motion for reassignment and was prohibited from opposing the motion. It is worth noting that the court agrees generally with Judge Glanville's assessment of the propriety of the ex parte meeting. Insert my concern. While the meeting could have and perhaps should have taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. However, in his order denying defendant Kendrick's motion and in the process of making his record on July 1st, 2024, Judge Glanville added facts, provided context, questioned the veracity of the allegations, and otherwise explained his decisions and actions and argued why those actions were proper. While it may be appropriate for the judge to disclose information relevant to his potential recusal, such a disclosure must be made in a way that is as objective, dispassionate, and non argumentative as possible, so that the judge is not reasonably perceived as a hostile witness or advocate. Insert note that Brian Steele did add him to the witness list. He plans to cross examine him in this case. Y'all, I can't wait for that. Anyway, in presenting his record as to recusal issues and in ruling on Kendrick's motion, Judge Glanville, party resisting the judge's disqualification, and by attempting to refute a charge of bias, a judge may become or appear to have become an adversary of the party seeking his disqualification. Judge Glanville evaluated and accepted the truth of his own factual allegations mandating his recusal. The court has no doubt that Judge Glanville could and would continue presiding fairly over this matter if the recusal motions were denied, but the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from further handling of this case. Based on the foregoing, this court hereby orders as follows. Defendant Deamonte Kendrick's motion to recuse Chief Judge Ural Glanville is granted. Kalen Bumpus' motion to quash the show cause order and to recuse Judge Glanville is denied as mute. Defendant Jeffrey Williams' motion to disqualify recuse Judge Glanville from all further dealings in the above referenced case as amended and supplemented is granted. The clerk of court shall reassign this case using the court's case assignments procedures. It is so ordered this 15th day of July 2024. The Honorable Rachel Krause, Fulton County Superior Court, Atlanta Judicial Subject. Well then, guys. I'm going to be honest, y'all. I didn't expect that to happen. I did not expect that to happen, y'all. I just have to be honest. I didn't expect that to happen. There was so much concern about this judge because one, she is his subordinate. There were pushes to get her to recuse. They were wanting this case to kind of be moved, this hearing to be moved, and she did the right thing. I think that her explanation, of course, of him breaking the law, and we've already kind of covered the corruption of it all. Should this have not been in a like a big public kind of stance, the brazen corruption in this court, but for him to hear his own case and deny it and to argue the points, those were the points that she used to go ahead and recuse him. Had he not done that with this ex parte meeting that he had, he may still be on this case. But thank goodness the efforts to preserve the confidence in the court system, because, honey, that really was a question. It was definitely a question. So he has been recused and removed from this case. Y'all, I am more tuned in than I was before to see how this case is going to go about, given just how brazen everything, how everything has transpired so far. So it will be reassigned to a new judge. I think that there are some motions to kind of move it out of Fulton County. I really don't blame them for that motion, but we shall see, and I will keep you guys posted. I thank you for the subscribers that have tuned in to this live. Please, if you have any questions or you want to give any commentary, definitely just post something in the chat and I will bring you up to the screen to discuss anything further. If you guys would like, I'm going to come back in 30 seconds. I'm going to pull up a video, and I'm going to come back and give you guys some audio on the argument between Judge Glanville and Brian Steele when Brian Steele realized that this had happened and they were going forward and they were arguing. I'm going to pull that audio up for you guys. So just give me a moment and I am going to add that. Okay, guys, I'm back. I just wanted to play the audio of this heated exchange between Judge Glanville and the attorney. I wanted to play that for you just so you can kind of get a feel of how heated things were in this court. And then we're going to conclude this live.
Tell me how you got the information. Listen, tell me how you got the information, then we can go ahead and go forward. I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court. It concerns me that you have proprietary information or information that you should not be having that was ex parte. Why? With a party. Why? State of Georgia. How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years and then supposedly that's out of a court. Okay. Well, excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said actually all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we've by the judge. Mr. Steele, I don't want ex parte communications that and then all 26 people in the court supposedly said, and he'll sit for 2 years and then supposedly that's out of a court. Okay. Well, excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we've by the judge. Who's right to be present for. So I understand that you're upset towards me, but what I did, Mr. Steele, I still want to know, how did you come upon this information? Who told you? What I want to know is why wasn't I there? Why, sir, I'm going to hold you in contempt if you don't tell me who that. Tell me who this information was coming from. In contempt. Well, then answer that question. That's attorney-client privilege information. I'm not attorney-client privilege unless you were in my chambers. That's the only way you can figure out. I tell you what, I'm going to give you 5 minutes. If you don't tell me who if you don't tell me who it is, I'm going to put you. I'm going to put you in contempt because that is not attorney-client privilege. Attorney work product privilege. How did you get that information supposedly from my chambers? Did somebody tell? See, this is the problem with the judge. He thought he's letting himself be exposed. Why are you so mad? What's so? That's wild work. The Copeland statement too. I feel like he gave himself 5 minutes deletion or something, but like standards or why on that is no. But expecting it to go the way it happened, it was kind of.
All right, so I'm going to end that with that piece that got really heated. And that is what kicked off these recusal motions. And again, I do find it interesting that this judge finds nothing unusual about this ex parte meeting that had taken place. But thank goodness Judge Glanville kind of argued his own motion and entered in some of his own defense. And yeah, he has been recused by one of his superiors. I'm sorry, one of his subordinates. And I think she'll still have her relationship intact because she cited case law. He can't argue with that. I mean, I guess he could. He's argued with some other things, but anyway, it's your girl Duchess. Thank you for the guys that tuned in. I'm sorry, the subscribers that tuned in for the live. I will be popping in and covering this situation, y'all. It's kind of getting heated for me, but yeah. Anyway, happy Monday. Enjoy your day, and I'll talk to you guys soon. I'm out.